this study session of the Littleton Licensing Authority to order. And on a formal agenda, is that
correct. We don't have the only item on the agenda is proposed amendments to Title III, Chapter 2 of the City Code regarding liquor licensing.
All right, would city staff like to walk us through?
Okay, so as you hopefully will recall, a few months ago we decided to undertake this as kind of a group process, and as a result, Vice Chair Levere and Authority Member Day had provided some information to staff regarding changes that they would like to see made, or those that needed to be made. And then in addition, we have gone through as staff, you'll notice that there are a couple of sections that we've completely removed or are proposing that we remove, and we can certainly go through and talk about those sections and the reasoning behind it. And just to clarify again, the reason that we're doing this is to bring it in line with changes that have been made at the state level over the years. The last major overhaul to this was in '95. There have been some random ordinances over the years, the last one I think in 2012, and it was a minor modification. And of course there have been changes to state liquor code, there have been changes to internal policy and procedure. So we really were trying to bring it in line with that. Vice Chair Levere did point out that we will probably need to look at this again after the first of the year, sometime during next year, because after January 1, 2018, they will start rulemaking based on Senate Bill 16197 in regards to 3.2 malt, fermented malt, which will take effect January 1, 2019. So we'll probably have to look at some other amendments then. It's probably a little early to do that now, but I think if we get the rest of it cleaned up in the interim, it'll be a much easier process moving forward. And it might be something that we as an authority want to look at once a year just to make sure that we are still current, kind of thing. So,
real quick for our legions of fans at home, what we're looking at is on the website.
Yes, it's all available on the website. If they want to follow along at home, thank you.
Zero.
Yes, all of our many fans. So one of the first areas that we started in 32-3 paren B was the table of fees. And I've added lodging and entertainment. It's a new license type. This was created by state liquor enforcement because we had a lot of, and by we, the state, as well as the city, there were licensees that held tavern licenses that did not fit the description of a tavern, which is someone who sells alcohol by the drink. But we also have a spa in town that holds a tavern license, and we have a tea shop in town that holds a tavern license because they don't qualify for a hotel and restaurant, they don't have a kitchen, they don't have a bona fide menu, they don't serve full meals, and a beer and wine license isn't sufficient for what they want to do. Okay?
So this new license will offer.
So the new license will work for the spa, does not work for the tea shop, so they've opted to maintain their tavern license. And there's still some conversation at the state level about whether those will be able to be grandfathered in and then still transferred or not, but that's a risk they're kind of taking right now. So the lodging and entertainment license really works very similar to a tavern license. It allows them specific types of businesses, and I can certainly provide you a list. The only one we're really going to have to be concerned with is our spa. It also includes arcades, movie theaters. Alamo could just as easily have done this license, but there's nothing in it for them to convert or anything. Their food requirements are similar to a tavern in that they have to make snacks and sandwiches available. Doesn't mean they have to have them, it just means they have to be available. Could be takeout menus, could be, the number to Domino's up on the wall. Most of them usually have pretzels or nuts or chips or a microwave pizza or something like that, but they don't have to have a bona fide menu and serve full meals. So, okay. And then you'll notice that we took the last one out, and this was something that we've discussed a couple of times. This was deemed unnecessary because it's no longer against state law, or you no longer have to have special dispensation to sell after 8 p.m. or on Christmas days and Sundays. That's all gone away now. So there's no reason for us to have that extra occupation tax fee in there. The one area that we may have to look at are new item 9 and new item 10 technically, which, actually no, I guess it would be 9 and 10. So that would define like a brew pub. means you can consume on their premises or off. So what Breckenridge used to be, what, I can't even think of the name of it. I'm sorry? No, Locavore is a brewery. They're an actual
I see, not a
brewery.
brew pub.
So a brew pub, Old Mill, that's why I had a mental block. Because it's on and off, their occupation tax would be higher. Right now, we have no brew pubs, we have no distillery pubs, anything like that, so.
Just remind me, what is the difference between a brew pub and a brewery?
A brew
I mean, I know
pub,
that a brewery is obviously regulated on the state level, but why?
correct. So a brewery, again, operates, they do not have to have food. They have to make snacks and sandwiches available, which is why most of them partner with food trucks. They are state regulated only. A brew pub would be a restaurant that also brews some of their own beer. It's similar to a vintner restaurant like Angelo's Taverna, where they have their own wine.
So it's in connection with a restaurant.
Correct.
Something like a rock bottom or something. I was thinking of like a
Exactly.
very common one, like
Yeah, something like that would be a brew pub. Any place that you could go in and purchase at your table a product that they make, but then you can also buy as growlers or six packs to go right at their restaurant. So that's the difference there. Currently, we do not have one. Okay. So those are the changes in the fees. The next changes that we get down to, and we'll just go through the changes and then we can go through the whole thing if you want, or if any of you have other areas that we need to double back to.
Is there a distinction between a fee and the occupation tax? Are they one and the
Yes,
same?
they are not the same. Fees are going to be licensing fees, renewal fees, application fees. The occupation tax fee is a separate fee. Not all cities charge them. Littleton happens to be one that does.
So a fee is what we're looking at on this table.
Correct.
That's when I go to apply, I'm going to write a $720 check when I go to the meeting.
Right, so actually it's going to be this plus the license fee. So when someone is renewing a hotel and restaurant, their renewal fee is actually $1,255. It's a $75 licensing fee, it's a $100 renewal fee, and it's the $1,080 occupation tax.
Okay.
Correct. Okay?
How do they determine the occupation?
Oh, that's a question I wasn't prepared to answer.
There's no like,
from the state.
I don't know that it comes from the state. I can do some research on that and tell you where these numbers came from. But again, not every city.
it doesn't matter.
Well, but it might matter to some. How many of the authority want to know?
I'd be curious.
Okay.
Now that you're asking.
Yeah, I'm curious to see if.
Yeah, now that you brought it up, well, that's why it's different based on licensing fees and things like that. But okay, homework for me. I'm good with that. I'm on it. Thank you, Jerome.
Sorry.
That's okay. Don't.
So it's an occupation tax. Is it like Denver's head tax?
Since I'm not familiar with that, I couldn't.
Well, that's what employees pay for working in the city of Denver.
Again, I don't know. I need to do some research on it for you, and I will happily do that.
But it's a tax, not a fee. A fee goes to process, like the work it takes to actually process, and pay us all that you pay us.
Correct.
It's
Yeah, your big,
another word for
your
Yeah.
big checks.
Right,
Yeah.
but there is a distinction between the fee and the tax.
Yes.
It's Tim's salary. He's such a high salary here.
Well, and my question is, we're adding the entertainment and
Lodging and entertainment.
Lodging and entertainment. You've assigned 1080 for that.
Because it falls in line with a hotel and restaurant, a tavern, a beer and wine.
Right.
Yeah.
But
As far as licensing from the state.
that number was not derived from the state.
Right, so that's why I'm saying I need to do some more research for you.
My only concern, and this is why I brought it up, is if this is considered a tax, does it invoke Tabor in any way? Or
No,
it has to be.
I can tell you no.
Okay.
It does not.
All right.
Yeah. Look, one thing I can answer.
I just want to make sure.
Y'all
we're
are
working
tough
with it.
today, okay?
We don't say the word, we don't say
Yeah,
that
that's a
word.
four-letter word.
Worked earlier.
That's a four-letter
It's
word.
actually,
So,
No, it is not. Tabor is a four-letter
well,
word.
then this is the fee, not a tax.
No, it's a tax. It's a city tax. That's why not
Just
every.
all depends on how they write it.
Yeah. So we can keep going round and round, but I don't have the answer for you until I do some research.
It's a fee called a tax, but it's not a tax.
Basically.
All right, moving on to 328.
Can we go to 327?
Yeah.
Just one minor thing here is I've been to some of our establishments and the liquor license they display sometimes is behind a bar and kind of a place where the public isn't supposed to go look at it.
Well,
Is that a problem or?
no, it's not. Actually, it should be as close as possible to the area that they're serving liquor. So if it's behind the bar, and it's not necessarily there for patrons, it's there if we go and check on them or if the state goes and checks on them.
Okay,
Yeah.
that makes sense.
As long as it's up. Now, if you go into any of our establishments and you can't find it,
that's a problem.
that's a problem. Let me know, and I will reach out to the manager. I've done that at a couple of places, and I've been told, oh, we took it down to move it, it got broken, stuff got spilled on it. I can always get them a copy. I scan copies. So if you don't see it posted, and you're not comfortable saying to them, where's your liquor license? You'll go into some places, like when you go into the Safeway, all of their permits and licenses are on a bulletin board up in the front of the store, which just makes sense for them because liquor is everywhere in the store. It's not all just in that back corner. So,
And remind me again, there are several instances throughout here where it says it shall be unlawful to. Is the remedy just in a separate section, or is it anything that an establishment does that violates the various language of it shall be unlawful to is a potential violation that they can therefore be punished for?
correct,
That's okay.
correct.
So I'm just like practically speaking, we wouldn't actually like pull someone in if they refuse to put up their.
Well, if they refuse to put it up, yeah, we probably would.
We could have it.
If we find out that it's been damaged in some way and they can't put it up, then we're going to help them remedy that.
Okay.
Yeah.
If they refuse to remedy, then we'll escalate.
Well, then that's a different issue.
Okay.
Yeah. It has not happened to my knowledge, but that's a completely different issue. So yeah, a refusal to do it is different than not being able to physically do it. Okay? 328. And again, Authority Member Levere pointed out that he's busy with this. He's going to be able to do my job soon. I like that. That this was pointing to a repealed statute. And so on his advice, I went in search of Article 18 and Title 18 and found out that it's actually Part 102 that speaks to the controlled substances that used to be in the old section.
That's exactly why we are updating this.
This is why we're updating this. This is correct. Special event permit fees and special event permitting. Up until very recently, last couple of months, any special event permits, and for those of you who don't know what those are available for not-for-profits who are doing fundraising so that they can license on a temporary and very specific basis a specific locale to sell alcohol beverages and raise money. Western Welcome Week are all run under special event permits. The Elks, when they do their pig roast and their car show, theirs are run under special event permits. Most licenses cannot run concurrently with a special event permit. There are a couple of types that can. The club license, which the Elks holds, and arts licenses, which would be Town Hall Arts Center and Hudson Gardens. They can overlap. Any place else, they cannot overlap, okay? So up until a couple of months ago, we included the state in our approval process. But what that really meant was We did all of the background. We ran backgrounds on the applicants. We verified that they had possession of the premises for that date, for those times. Made sure that it wasn't going to negatively impact the surrounding community. Posted the location, gave people a chance to come in and say, no, we don't want it to happen. That in 6 years, I've had one phone call. And then they didn't want to come to a hearing. So a couple of months ago, we took the state out of the process. It's one of the few places in the liquor code that municipalities can opt out of. And so we did, because it was extending our timeline. And it's also an extra cost for that not-for-profit who's trying to raise money. So why would we want them spending extra to get a permit? So we approve those all locally. Those are actually done by the city manager's office. They start with me. We do background on them through the police department, and the city manager signs off on them. And so we've amended this to just say that when they submit their application, they're really only paying a local fee. They're not paying a state fee anymore. Okay? So that's what that is. And then authority member, everyone say it with me, Levere. Thank you, Vice Chair. So you had a concern about definition of public place, which was repealed in this part of the code in 88. But if you'll look at that little number 1 right next to place, it actually now lives in the overall definition table for the entire code.
Okay.
So that public place means the same thing throughout the code now.
Okay.
Okay? So we don't need to do anything there with it because it already lives.
Okay. I'll stop you there for a second. Just above that in B, we have a pointer to section 3223, which is correct, but in the red line version, when you've deleted 3212, I think it is, which is coming up fairly quickly, that pointer might be mixed up.
It might have to be changed because we're adjusting.
Yeah, when we take out 3212, should we,
Everything will move up.
everything moves up, we don't want to leave a holder and say,
So I think when we send it to Sterling Codifiers.
Yeah, they actually
will-
move
I
everything.
think they will change all of the
Yeah, they'll
Okay.
change all of the
I
links.
I think
think.
there's only 2 links.
But that's a good
That's
point to
something we
make,
will
and so
look
I'm going to,
No.
yeah, I'm circling them so I can go back and look at them.
We'll note it and
Yes.
we will
And
double
Just
check.
make sure that it does.
Yeah.
Correct.
Make
So
sure
it's
that all
not
the
pointing to a place that
cross-references-
doesn't exist anymore,
Or the
or that's incorrect, exactly. Okay? Possession in or upon unlicensed premises, that we just actually went in and changed a little bit of the verbiage. There was a point made by one of the authority members, I'm not naming names, that if it's an unlicensed premise, there is no licensee. And so we've changed that to manager or his agent. So whether it's licensed or unlicensed, it's still going to be a manager or his agent. Okay?
Sorry.
Yep.
With the being manager or his agent,
So,
does a restaurant like that it has no licensee that isn't licensed? Do
they
they
still usually
designate?
have a manager.
Do they designate a manager? If they're not designated, does
Well, they
that-
wouldn't designate through us, but every restaurant has a manager.
Would we say
You
owner?
could change it to owner or agent.
Or what,
Well,
doesn't
owner, manager,
licensee-
or agent.
Doesn't licensee cover the business?
But
Yeah,
if it's
except
an
for it's an
unlicensed
unlicensed
premise,
premise,
they
they're
would-
not going to have a license. So we could add owner.
You
We
could
could
add
add
owner,
owner.
manager, or agent.
We could.
Is there? I mean,
And this is
Or
just
make you feel
broadly, there's a lot of gender-specific language. Is there any appetite to like change that as we go, or is that something,
We certainly
you know, the
could.
haze and then later on?
There's certainly
there's,
no legal reason to change it. I have.
like legally
objection.
it covers.
Their agent?
We
I
can
don't like
certainly.
there because it's not grammatically correct. Because
So you
it's
can
not.
say his or her.
Right, his or her.
Yeah, we
I just-
can certainly do that.
there's a lot of places throughout
If we're
the
changing it, I don't know, like I said, I'm not trying to create work just to do it, but if we were in there changing it.
I have no problem with bringing it.
Yeah, I
into
mean,
line of
legally, we
being
don't
more
have to, but we
gender
certainly can.
specific.
And if we're changing the code now, if we're amending it and correcting it, then now would be the appropriate time. Any other thoughts on that?
I'd hate to lose something on a technicality because of that, and in court you might.
Okay,
Unlikely, but
but it's,
I have
Lena had this whole
never,
scheme planned out. She's gonna.
I have never seen a case where a code was brought in. I mean, I'm not saying there isn't, but I have not, in my experience, seen one where a code was held to be ineligible because
Of a
you know,
gender
because of a gender specific
classification.
pronoun. But I certainly see no reason why we shouldn't be gender
absolutely,
neutral.
yeah.
But for the record, not there, which is the
Which is plural.
grammatically.
For the record,
For the record.
Chair Cole would prefer.
I'm gonna put there, but I'm gonna spell it differently in every place.
That would make me
They
so
are-
happy.
I'm gonna put like THEY apostrophe RE, I am.
Yeah, I would like that. Yeah.
Okay,
Use
good.
that one every time.
Yeah, if there's any throughs, if you could switch them
Like
off
switch
with
those
some,
up a bit, yeah, I like it.
Stick with this
THRU.
point.
Through.
You could be like Alabama and say thar.
Third, that's right.
An unlicensed,
Y'alls, we'll put y'alls in there.
Y'all's licensee.
Yeah, y'alls.
an unlicensed premise, if they did violate this and they
They would not come before us.
would not come before us, they go to municipal court or something.
Right, well, it could be done at the municipal, it would still be a site, they would be cited based on the liquor code, but it wouldn't come to the licensing authority because there'd be no violation of a license. It would go straight to municipal court. Or,
You
yeah,
have no authority over someone that's not
correct,
licensed.
correct, but it's still a violation of the liquor code.
Correct.
Right. So is that where you were going?
That's exactly where I was going.
I was just
I was
reading-
curious.
I was just reading your mind.
Yeah.
It's just getting in there, it's a little scary.
Plus, it's warm and cozy in there.
Got rid of legal
So-
information with kegs of beer.
Yeah, so item G you'll see is completely gone. There was a time when liquor stores and distributors had to, when you purchased a keg, they had to give you like all of this information. And to our knowledge and our research, it actually never came from the city, so we are not sure how this got in here to begin with. But it's been in there since 1985. So we're just
When I
getting rid of it.
originally read this, I thought you weren't allowed, I thought it was saying you couldn't give them any information.
Yeah,
Like you
no.
couldn't hand out leaflets.
And now they actually print stickers that go on the kegs that have all of the required information. Okay. Oh my God, look at how much we made it through without putting any red in. We are down to 3-2-12, unless Vice Chair Levere has,
Well,
we're gonna get back to
we can go back to
11.
11.
We're going to get back to that. Right now, we're just going through the stuff that we've already addressed. I know that there were several authority members that really wanted to look at 3 to 11 and each sub kind of in depth, so we'll get back to that.
Okay.
So 3-2-12, this was removed. Again, it's been in there since 85. We do not have a right as an authority to have access to their ongoing financial information. This is something that is now covered under finance that they would use if they ever had to file a lien against someone or take them to court on like sales tax issues or things like that. It's not under the licensing authority's purview.
Which you're saying it shouldn't be or it can't be?
It's not.
It is not.
Well, it is not if we make it so. But as
No,
of now-
it is not currently.
Oh, I see.
This has been in there since 85 and it shouldn't, I don't know when it should have come out, but it is not currently.
You mean under state? Well, okay, so, but.
So we have the authority or our agents, like the police department, have the right to go in and inspect their books, but we don't have rights to in-depth financial information. Like we might go in and look at their books, but we're not going to be pulling records from their banks and things like that. This is something, and again, I don't have history on it. I wasn't here in 85. I was running the streets of Hollywood with a mohawk, but that's a picture you can all think about tonight when you go to sleep. This is something that is now under our finance department's purview.
No, I get it. I guess I'm just saying this is what we're looking at that is crossed out is currently in the code.
It's in the code.
But you're saying it should not be.
It should not be in our code.
Got it.
Yes, that is correct. Circle that. So now we are down to what was 3.2-16, which would become 15, license renewal procedures. I just added a line in there just so that it more clearly mirrors what is actually happening. Because anything that's coming to the chair on a renewal is vetted through our police department and through the attorney's office before you ever get it. And so I just want that to be clear in the code, that it's not going straight from my desk to the chair's desk.
And so the city attorney's office does the right.
Well, it would be.
But does the due diligence?
Right.
Like
So
part of it going through your office is the police.
So what happens is when a renewal comes up, Deputy City Clerk will collect from the police department she'll ask for a background check, she will ask for any violations that have occurred. Then also we will reach out to finance and determine if they are up to date on their taxes. At that point, she will collect all that information with the renewal application. She very kindly puts it all into a PDF for me, sends it to me. I review all of that, and then make a determination, look at the application, make sure they have, they have
possession of
the premises. I'll double check to make sure that when it says that they're rented, that I can see when their lease is up. I check all of the police reports to make sure that it's all
right. So I don't necessarily want to put all that into the
right.
codes, but is there any? I mean, so as of right now, under paragraph B, it goes over violations. Well, actually, let's see. These are required procedures.
Right.
So I do all that due diligence before it comes to your desks, making
You
sure.
just make sure they dotted all the i's and crossed all the t's.
We do, and we make sure that any reports that we get back are not of an egregious nature that would kind of
renewal hearing.
Yeah, that would require us or compel us to bring it forward. Now, what we have done in the past, and we haven't done it with you yet, Chair Cole, but we have with past chairs. I know the attorney's office would reach out to the chair and say, this is my concern with this particular item, and they could have a one-on-one discussion to make a determination if it was something that the chair felt maybe merited coming before the authority.
Generally, we should be getting police reports as they happen.
Let's
say something happened, right before, and there was an egregious
and that was a
violation.
concern before, that we weren't getting them until a year later, and so they've been much better about bringing them forward as soon as something happens.
Things like that, or getting behind on taxes. The finance department is also very good about being diligent and letting us know when someone's falling behind. But should I see something in the report, in the application renewal that I hadn't seen prior, and I just thought, that doesn't look right, then at that point we would come to you and say, let's discuss.
If it wasn't something that the attorney's office, and we use attorney's office or city attorney to mean either Steve or Lena, it's the entire office.
There are but two of us.
Well, it's all two of you.
Yeah.
You're as big as the clerk's office. There's two. Hard to lose track of your employees that way. Yeah. If it was something that they just weren't feeling necessarily fully compelled, but we're kind of on the edge, then that's where you get to come in. So, okay. So now we are down to old section 32-19B2. Again, one of the authority members, potentially the vice chair, not naming any names, Tim, had asked about adding Jefferson. And so when I did some research on this, the reason it wasn't in here before is if you look at the date, 1985, it was before we annexed the enclave community of Trailmark. So we didn't have any Jefferson
And there's
County
no
properties.
nothing over by Canyon?
I think there's a tiny little,
Okay. Yeah.
like, you know, it's like,
And Wadsworth.
on a map, it's about like,
But in real life, that's like 6
well,
acres.
Trailmark is down
Right.
Wadsworth, but anywhere else on Wadsworth is not really us.
Well, the city of Littleton annexed that thinking that it was going to be a golf course. And
Not
that's,
so much.
well, that's what I thought. And
Yeah.
then the developer decided to change his mind.
Right. So, so we have added Jefferson.
Just for,
Well, no, I think it's absolutely, and it was a great catch, so.
Is there a Y in counties?
well, it used to be County of Arapahoe and County
I
of
took the
Douglas.
Y out. The Y is crossed out.
Okay, I see it now.
Yeah, so it used to read
I will
County
spell
of
it out
Arapahoe or
whenever I
County
want.
of Douglas.
You're being ornery.
Counties.
County.
I see that now. There's
Yeah,
a scratch.
so the Y is crossed out, and
Caught the
then,
spelling error.
And Jefferson County, you got.
Are you sure that wasn't a spelling change? You know, I've, since 1985, changed the spelling.
yeah.
You decide.
Okay, so now we are down to old section 32-23, now 21, optional premises licenses. Again, Vice Chair Levere. There was some odd language regarding the director, but the director was never established as to who that was, and that actually speaks to the state level person at state liquor enforcement. But with optional premises, they really just need to submit as part of the application process a written statement from the owner of the property that they are aware of the potential use of this space. And then that all goes to the state level, which eventually makes its way, much like any other application process that we do. Once we are done with it and we approve it, like the one we approved tonight, state will get faxed copies tomorrow saying that you all approved it.
And our
tonight.
approval is based on state approval.
No, our approval is based on our approval. State approval is based on
Well,
their,
their approval
is based on ours. Yes. Correct.
Is optional premise, is that what, like the pint room, use that extra space?
No,
No.
they do not have an optional premise.
Where they actually extended their,
Temporary.
They temporarily modified their premises.
what's the difference?
Okay, so an optional premise, we actually have a couple in our city that have them. One is Hot Stove Lounge, the Ice Ranch, Santoros, that's all one place. They have an optional premise that is contiguous to theirs that they use for storage, but there's nothing actually happening in there other than storage. It's contiguous, but it's not actually
It's a
part
part
of
of their license.
Yes. The other one that we have is Littleton Golf and Tennis. So the thing with optional,
It makes the whole golf course.
correct. So like the golf, you know, they can take the drink carts out and things like that. And the thing with an optional premise is they can turn it on and off. Okay? So they could decide for a particular part of the year, you know, winter when the golf course is covered in snow, they turn the optional premise off.
And
It's
then
no
it's-
longer licensed,
it's
everything
inside.
stays inside,
Okay.
yes.
Okay.
So that's what an optional premise is, okay?
On H, just to note that there's another pointer there, so make sure.
Yep,
that
I'm
goes.
circling it, thank you. I hadn't even gotten there yet. You slow down, Buttercup over there. Let's see. I believe that's it. Yeah, everything else that we changed, you'll see on the last page, these are all endnotes, and so these are the changes that came from Vice Chair Leviere's suggestions. These are the ones that are left here are the ones that I have not changed yet, because I think that we need to discuss them a little bit. You'll see that Authority Member Day wanted to go back and look at 3.2.11, which we talked about going back and doing. Vice Chair Leviere, again, conduct in establishments, which is where we're going back to. Parties in interest, you had some concerns about those, and so we'll go back to that. And so these I just copied your actual comments to me so that the rest of the authority could read them. Before we go any further, though, and go back to some of these sections, I did put a little note at the bottom to see if we wanted to add something in here about requiring tips or another type of similar training. And if so, what kind of parameters? There are a lot of municipalities that do require it. A lot of them, their police departments do the training, or they it becomes the responsibility of the licensee, obviously, but a lot of municipalities do require that they be tips trained or some similar program. We have never required that. We have usually used that as part of a violation, or we've used that as part of their sentence or whatever it is. And so we just thought we would throw it out there and see how you feel about it, see if you think it has value, if we want to attempt to put it into the code, or if you're good with the way things are going and you're using it as...
How would you like to see it in the code? As new establishments or all establishments?
Well, I mean, I don't know that we could, I think it would have to be from a start date. I don't know that we could go back to people that we've already licensed and put that requirement on them. I mean,
Well, you can
we
do
probably
it for them to
could.
renew.
Yeah, we
Yeah.
probably could as part of the renewal.
I think if that's a direction that the authority was interested in, I would say that I would suggest that staff do some research and outreach with other jurisdictions that have that requirement, see what their code requires, see how they apply
and how they
that,
transitioned it.
how they transitioned it, what they require, how often they require it, just so that we can get some more information for the authority to make that determination, but only if that's a direction that the authority is interested in.
I think there's merit in requiring it, but I don't feel the need to. I mean, I don't see like an alarmingly high number. We tend to ask when new applicants come in front of us, and in my memory, it seems like most of them indicated an intention to. Now, they might not afterwards, but like I said, I don't see any sort of like rampant.
Yeah, or if they've already been approved.
Right.
Yeah, it's easy if there's a violation.
Well, yeah, because you can always use that as part of the stipulation process.
Right.
Or do you remember Buchanan? Do you have?
I'd just be interested in learning a little bit more about what other jurisdictions.
Okay, I can do some research.
One thing that'd be relevant though is, I wouldn't want to be imposing another fee on somebody. So are there?
Well, there
Yeah.
would be fees involved in them becoming certified.
And is tips is
that a company or?
yeah,
What is that?
it's a process, right?
It's a
There are
process.
variety,
It's a
right,
process.
but a variety of
There are
private companies.
there are similar programs available. It's kind of like Kleenex is tissue, but not all tissue is
Right.
Kleenex. It's the same thing.
right.
But we call them all Kleenex
Jacuzzi and
anyway.
a spa.
Yeah, jacuzzi and hot tub, same thing.
My feeling on it is, I very much similar to the chairperson Cole. The thing I like about not requiring it is when that person comes in for their first violation, you can look at it and say, you voluntarily did this in advance, and this was important to you before you got in trouble, or you never did it before, and now you got in trouble, and now you might see the value in it, but you can kind of gauge, it kind of helps you gauge what they're voluntarily doing to proactively avoid a violation.
Well, we've seen a lot of applicants that come before us and they say they're doing the tips training.
Right.
But we don't require it, we don't know if they actually
Right.
do it.
Yeah, and so
I don't see a huge problem.
But you're right, it is an extra fee that we're imposing on them.
Well, is it, I mean, I don't know if there is somewhere that it's free in town, Jefferson County?
I don't think so.
if you do require it, you are adding to the clerk's duties to verify it for renewals or whatever, or however we stage that.
Right, but that's, that would be up to them to submit with
Yes.
their renewal. I mean, the responsibility is on them, and we hold up the renewal if they don't. I mean, that's
And when it came to new license, it would be just a part of.
part of the
that
application. It's part of
presentation
doing
that they
business, kind of thing. But if it's not something that, I know Authority Member Buchanan has said he would like to see some research on what
I mean,
other
I don't,
municipalities
if
do.
you
I
want to do
I
some
can
research,
absolutely do it,
and
yeah.
then we can just discuss it further.
It'd make us more knowledgeable, even if we don't put it in, we'd understand it better when we're talking
Okay.
to applicants about it or when we're utilizing it as a sanction.
No, absolutely, I can do that for you.
How many licenses?
Does the city have right now? Just over 100, and that's between 3-2 liquor stores, beer and wines, hotel and restaurants, taverns, what am I leaving out?
Vintner's restaurant.
One vintner's restaurant, yeah.
So I don't do this now, but if we were to continue forward with the discussion, I'd be curious to try to do a survey and ask how many current. Just volunteer, just send an email and say, this is an item for discussion. Do you currently have a certification? But like I said, let's not do it yet. But if we were to think about continuing to move down the road, in any case.
We could certainly put something together if that's, or we could, well, absolutely, or we could certainly, if it is something that we wanted to move forward on, we could even put it on the agenda as an item and invite them to come to a meeting
Give us the
and come up and talk to you and say, this is why we have already done it, or why we haven't, or why we think it's a good idea, or whatever. And then you can hear right from the business owners or the managers, or, if that's something we wanted to do too. So yeah, we can do that. Okay, so let's go back to some of the sections that there was concern about.
3 to 11.
Yeah, I think we're going to start with 3 to 11 and just kind of go through each. And many of these come directly from state statute, and they're just mirrored in our statute or in our code. So if you want to just go through them and have a discussion about them, if there are any that jump out at you, don't make that face.
No, this is my eager face. Okay, we'll start with A, number 1. Maybe if I say this aloud, no licensee or employee shall install, maintain, or operate, or permit the installation, maintenance, or operation of, within or upon the licensed premises, any gambling table, establishment, device. What is establishment?
I don't know, this was done back in 1985, so why that word's in there, I don't know. I mean, we could
I
certainly,
think it correlates to the end of that sentence, right?
potentially,
Used for the purpose of gambling.
yeah.
Maintain or I believe establishment probably correlates with maintain or operate an establishment. So if you break that up, and does that make sense? Like they're saying you won't install, any of these divide these things, you won't maintain or operate an establishment. I'm not saying it's the best way it could have been written, but my
Secret establishment.
my understanding of that would be that that's what it's saying, is that you will not maintain or operate an establishment.
Backroom. Okay,
Yes.
yeah.
Yeah,
Okay.
you know, Fight Club, what's the first rule of Fight Club? Don't talk about Fight Club.
I'm not going to talk about this.
Secret.
The first rule of Fight Club is you shouldn't use 14 prepositional phrases in
Right.
a sentence.
That's the first rule of writing code.
Is
have to
you
have
should have used 15.
Right.
Yeah. Yes, and we've had the conversation, both with attorneys and in the clerk's office, that this isn't always written in layman's language, but there's also a reason it's written this way from a legal standpoint, I think, a lot of times.
I have so far resisted the urge to demand that we take out said.
I'm going to capitalize it now and put it in bold.
Attorneys love that word.
I know they do. Said license.
Said premise.
Said. It's just not a term that.
Well, if it annoys you, we can take it out. Lena says no.
Said Lena.
Yeah, said Lena.
Well, if this is just copy and paste from state statute.
Much of it is. Now,
I'm unsure about that section.
number one, I don't believe is. Number one is ours.
You have to change a few things or it's plagiarized, right?
There's a lot of plagiarism.
Yeah. See, the thing with liquor code is, being a dual licensing authority, and some municipalities have done this, their entire liquor code is, we have adopted the state liquor code. That's it.
End of story.
End of story, they are done. If it's not in state code, we can't do it. If it is, we're doing it exactly like they do it. With dual licensing, though, what it does allow us to do is we can never be more lenient than the state, but we can be stricter than the state. So that's why many municipalities do have their own liquor code, because they've opted to add in some items that maybe the state is silent on. The state doesn't necessarily speak directly to it.
And the reason the state gave the city some authority, Fort Collins said, we don't want marijuana at all.
Correct. Yeah, none of it.
Yep.
But with some of the things, I think, like the definitions may be directly from the state definitions, just
Absolutely.
because if there's already an existing definition that works,
Right, then we'll use those.
why attempt to write your own?
Right, and so some of these definitions in one might be coming actually from gaming. Okay. So any other discussion on number one? Each licensee and employee shall conduct his business or his establishment in a decent, orderly, and respectable manner, shall not permit within or upon the licensed premise the loitering of habitual drunkards or intoxicated persons, lewd or indecent displays, profanity, rowdiness, undue noise, or other disturbance or activity offensive to the senses of the average citizen or the residents of the neighborhood in which the establishment is located. Any licensee hereunder and any manager or agent or employee of a licensee hereunder shall immediately report to the city's police department any unlawful or disorderly act or conduct committed on the licensed premises.
I do know over my however many years of serving, there are times when, activity offensive to the senses of the average citizen has been a little bit hard to nail down, but I also realize that that's like really standard liquor code. So I don't have a huge appetite to try to
To
take
define
on,
that.
Also,
yeah.
the reasonable person standard is illegal. That comes from, that's
Right.
probably
It's like case law.
mired in that reasonable person standard,
Right.
which in and of itself is a quite difficult standard to
Right.
actually pin down.
So I want to mention it that
Right.
it can be difficult, but like I said, I don't have a huge appetite to
Okay. To change it or to try.
There is-
make a suggestion to
I
council.
will say there is some case law that says that it's pretty much what I think this had to do with profanity, but it was, or lewd, it was like, what if your grandmother would find it offensive? And I believe the court may have used.
It depends on which one of my grandmothers you're
Right.
talking about.
Well, and there's also some utility in something that's more relevant.
Yes,
So it's gray for a reason.
right. I believe that is best.
I'm kind of looking at this list of things not to permit on the premises. And, I mean, when we say, okay, the manager should not, or the employee shall not permit profanity on the premises, and this guy's like, oh, that's effing, I saw that baseball play, and that's effing crazy. And are we supposed, if he doesn't kick them out, we're supposed to haul that manager in and say, you let him say the F word. I mean,
But I think this goes back to the average citizen where if you are in a group and if someone came to the manager and said, that guy's being really obnoxious, that
I
you
think
have
there's-
you have already crossed over to the average citizen
I
saying,
think there's probably some reasonable, I think that's where the average
There's some reasonable
citizens
exception.
comes in. I think one person yelling out a swear word probably doesn't qualify, but if you have somebody who comes in and is constantly stream of profanity,
and there's context. I mean,
And being
what goes on at
profane-
1:30 in the morning
It's different than what happens at 5:30 when you're having dinner with your family.
with your family. So
That's certainly
we got a
something-
comedy club that came in and they hosted the most profane comics you've ever heard. George Carlin comes back from
Red
the dead.
Fox.
Red Fox.
Basically, he's the dirtiest guy in Vegas.
Let's
Prior, yeah.
let's assume that these people, the average citizen who was there, didn't bring it up with the manager, but they came to the authority or to the clerk and said,
Well, first of all, I'd say, why did you go to a comedy club where Red Fox or Chris
Right.
Rock or somebody was performing? That would be job one.
yeah.
I certainly
Or
think
David Tell.
if
Come on, if you've heard
if
some.
you would like, we can certainly look into the reasoning behind that being in there. We can look into other jurisdictions and see what language they have. We can certainly do some background in determining if the way that this language is written is necessary, and if there's a way to clean it up. I can see
got
what Vice
clean it
Chair
up,
Lavier's
I've been there,
direction
and
might
most
be
of those
going
comedy
to-
clubs
to.
have a disclaimer before the comedians come out anyway.
Yeah.
I
Say if
see
you're-
what
if you're
talking
gonna be
about.
offended,
It's a
you don't
general
need to be here.
restaurant bar.
And let me walk that back because kind of reading this, we don't want establishments putting profane language on their signs or things
Correct.
that outside the establishment. And these
That's
would have
under
to
the
be
sign code. by
these
the
would
way.
have to be offending to the senses of the residents of the neighborhood, not the patrons of the establishment. So I think it's more maybe directed towards having kind of a bad smell in the neighborhood than having a bad smell inside the establishment.
Maybe don't have an air horn and start yelling swear words off your deck.
Yeah. Okay, so
Well, what am I
I'm
supposed to
fine
do
with
on
it.
Saturday nights then?
July 4th.
Not bad.
So you were saying you're fine with?
I think I'm
Yeah.
fine with where
Yeah,
where it is.
I'm really a little worried we start really going down a rabbit hole here. There's a lot of words here, but it's still very broad and it gives a lot of discretion to the board. And we're not an enforcement authority. No one's going to come to us, even if they did and complain to us. They're going to go to the police first. And
Correct.
there's the systems in place.
Correct.
We would use our best judgment as unpaid public citizens, and then if someone really cares, they go to court, and the court gets to figure out what it means.
So I think then we're just going to skip down to number 7. Because I do have an end note on that. And Vice Chair Lavier, and I'm using his name proudly this time because this was a big one, did remind us that we do have in our city Alamo Drafthouse Cinema, which is licensed under a hotel and restaurant license, and they do show. But it's not all fluffy family films. As a matter of fact, they have a sign on their door that says nobody under the age of 18 unless accompanied by a parent. So, which is why a little cocktail with my dinner and watch a movie. So I think that there's an opportunity to clean up number 7 in a broad way, so that we're not singling out Alamo because they happen to be the only game in town right now, but that doesn't mean that they always will be. So we really can't take a section and fix it just for one business. It has to be done in a much more broad kind of way. So let's look at what your suggestions were on that. Let me take a peek here.
We just opened an Alamo Draft House
Down by me.
in Lakewood.
Yeah, it's on Colfax. Sounds like it's not as nice.
Okay,
The
that's
bar's
not-
nicer,
That's
but
not the point.
just saying.
The point is, I'm wondering what Lakewood.
I can look at their.
Is it Lakewood?
Yes.
Yes.
Does Lakewood have strip clubs and other establishments like that?
I hope not. I live in Lakewood.
Yes, they do.
Shh.
Colfax is at
I'm
Lakewood,
just
right?
wondering if they have similar language
My bathhouses.
and how they have dealt with that. And then similarly, I think are there other
Well, Highlands Ranch has AMC and they have a liquor license.
Yeah, but I wonder if there's anything in their code that speaks to it. So let me do
that
some
would be
research.
Douglas County.
I'm even curious, is this some antiquated rule? I mean, why would this even-
Potentially.
Well, it may have had to do with licensing establishments that might show like stag films or.
Right.
Well, so, but actually, to the point, can we
Can we
strike it because
and then it's a non-issue.
Well, under a legal standard, let's see. Shall not permit.
Still, I
I mean, lewd or indecent displays, profanity, rowdiness, undue noise, or other disturbance or activity offensive.
I mean, I think
I
a
would
lot
think
of
if
that
you
is
were
already.
showing a snuff film on a video screen, it would still be an indecent display there. So I guess is there utility in just striking the section and letting the rest of it speak to?
Let the rest of the subsection speak
Yeah,
to
so
what
that-
is.
Let's take that.
I mean, I know what you're saying is that you'd like to offer protection for, but
But then that would also have to do with.
again, it goes back to context. Like
Well,
if you go to Alamo Draft House to watch a
50 Shades.
then you're not, I mean, there's some level of understanding of what you're doing there rather than if you're
Let me give you a different example. This would, if you take your kids into Rip City and Rip City has pictures of naked girls stapled to the wall, is that a problem? Because that's what this section would eliminate. And so if we take this section out, now,
see, would
I
it
think
though?
number 1 would cover that.
I still think under number 2, it would
Yeah,
still
I
be
think-
an indecent display.
Yeah, I think it would be
like,
covered under
just
number
because
2.
it's not a live person.
Yeah.
I think.
I think it would
I guess we
still-
can look at the case law as to an indecent display, but it seems to me that or under the let's see, or under or activity offensive to the senses or other disturbance or activity offensive.
It would be a lewd or indecent display.
Yeah, I don't know. I just wonder if the least complicated way of going about this
Would be to strike it. Does the assistant city attorney want to?
I would want to do some further research into that. I think what we need to nail down is what it is that you're trying, what the heart of this is trying to get at. And I think that directs a little bit. I think that if you're trying to prevent lewd and indecent displays, things like people showing snuff films in bars or having pictures of naked people up on the walls, I think that probably is more towards your lewd and indecent displays. I think I would want to do a little bit more research to figure out what this was directed at, if this is, because I think you really could have a concern with something like Alamo Draft House showing an R-rated film, which very easily could have any of these things listed in lewd or indecent displays. So I think we need to figure out what we're trying to do and what the best, if the best method is to strike this entirely, or if we still remain with the same potential issues even by striking this language, and do we need to call out in the manner you suggested in your notes?
a rewrite.
you know, a rewrite and that somehow carves out an exception for a business of that nature that has that their whole business model is to show films.
Right, but it may also come back, because I think that lewd or indecent displays pretty much calls out what those would be, and maybe we rewrite those to include stills and things like that versus just an actual physical act, and then we could strike number 7.
Well, you still have the problem of film.
Protecting their right to do it. Right?
And if you had a bar, I mean, if you're just talking
friends
about
watch
physical
party.
acts, I mean, if you just had a bar that had a TV in it and they're, you know,
Yeah.
showing.
All right, so some research.
Yep, I'm on it.
The other part about leaving this intact the way it is, in any form, this last bit, depicting any act or live performance prohibited by this section. Well, gambling is prohibited by this section, so are these licensees in trouble for showing World Poker Tour?
Oh,
That's an excellent point. Certainly something I will consider. We will do some research on this, and if the board, if the authority would like, I am certainly happy to come up with a little communication of some sort to explain, you know, the direction I would suggest that you go in and any potential ramifications from leaving it as is or changing it. That's something the authority would like.
Yes, please, thank you.
Okay, we'll work on that then. I'll do some research, and then Assistant City Attorney and I will work on that. Okay? I think the only other section, parties in interest, which was 3.2.15, now 3.2.14. Vice Chair Levere was concerned about the language of cross-examining witnesses. And so I'm going to let Assistant City Attorney McClellan speak to that. His concern was with the verbiage here that says cross-examine witnesses infers a lot more involvement and interaction than presenting evidence or testifying. It might be as simple as asking a question for clarity, but in a special circumstance could be much more involved, such as having a back and forth, devising additional questions based on responses to previous questions, etc. This section does appear to be limited to a public hearing for the purpose of establishing the needs, desires, and requirements of the neighborhood, not for a violation or other order of business. For this section, I have no suggested changes, but if it does not change, I think we should modify our procedures to call for parties of interest and treat them in a different manner than general public comments from outside of the neighborhood or even city.
That term there, that cross-examine, is a term of art. I see where you're coming with that. You could just change that word to question, instead of cross-examine, question witnesses. And then even if we left it alone, I would think that there's an inherent authority in this authority, and particularly with the chairman, to control the proceedings. You're in charge of these proceedings, and if somebody is abusing that, which I think maybe is a concern that you're getting at, that the chair would certainly be able to cut somebody off and redirect and control that process. When somebody's trying to get abusive or is going, they're being duplicative or irrelevant,
Which we have done before.
But that word does cross-examine does kind of stand out there, and maybe just
Almost
changing
like
that
that
to
should-
question would make
Almost
it
like
less
question.
of
I
a
would
Perry
almost
Mason
say
kind of thing.
it could be stricken out altogether.
The whole section, or?
No,
Just
cross-examine witnesses
Just the term
Present evidence
cross-examine.
Or testify.
or testify. Period.
Or ask questions.
Present evidence, testify. But now, see, I understand where Vice Chair Levere is coming from, because, let's say I'm an inhabitant of the neighborhood, so I am a party in interest. The way this is written, I would then have a right to come in and question the
And call a
applicant.
witness.
And question the applicant, which really isn't what we do in a public hearing.
Right.
Well, I've never seen it, but it doesn't mean that we shouldn't have it.
When I was on the Englewood licensing board, there were several licensed, particularly medical, it was a growth facility in particular. And the local residents were very concerned about it. They didn't have a lawyer, and we allowed them to ask questions of the applicant. And it was useful, and I think I wouldn't want to preclude
That from
the ability
happening.
to allow that so that the
So
local
then,
citizenry could feel that they've been heard, because if you
Right.
just automatically cut them off, oh, you can't ask questions, we don't allow that.
right. So
That would-
then,
But isn't there a difference between allowing it and having it in the code?
Well, no, I would, as the chairman, I would rather, if we're gonna allow it, I'd rather have it in the code.
So that it's
So
clear.
that
And
it's
I would say
clear.
my concern would be because of the nature of the hearings. I think the more procedure that you have that's
That is spelled out.
sort of set out and
That's
spelled out.
clear, and it's available
Yeah.
beforehand, so we're not, they can't
Right.
say that we're.
And
and so I think I
And
like.
my guess is because of the nature of your hearings is probably cross-examine was put in there as a term of art. And that's probably the reason that language was used to begin with, would be
Yeah,
my
but,
guess.
I mean, the way we do it, so for tonight, if someone had come in and wanted to, I mean, we could always, I mean, the public hearing isn't closed yet, so we could always
You could
essentially
always bring-
transfer the question over, but I agree with your point that if a citizen, I mean, yeah.
Well, and
If a
what's
citizen got up and said, I have a specific question, like I said,
But see, the
I would be
question-
happy to say of the applicant, can you stand back up and answer that?
Right,
I just
and that's
understand,
generally what happens in council, is if someone comes down during a public hearing and council finds that question or concern to be helpful, then they generally will, when that citizen is done with their 3 minutes or whatever, call the applicant back up, call whoever it is, and say, do you want to address that question or concern? But really, it's the council that's controlling that.
Right,
It
and
is
they
not.
pose the question.
Right, it is not the citizen who is doing
Because,
cross.
again, the point is that if
They are
if
posing
none
a
of us
question to
chose
the authority.
Yeah, if none of us chose to, then no one would have to answer their question. So it seems like it's nice to have it in there that they do have the opportunity to.
But do we want to say cross-examine, or do we just want to say question?
Oh, I see.
I think
I'm okay with the question.
the applicant brings their lawyer in to cross-examine themselves anyway.
Well, yeah, but that's just them, and they don't always bring an attorney, I mean,
True.
I was, but,
I am unaware of why that was put in. I was obviously not here
Well,
in
neither was I in 85, but
1985.
you weren't even born.
I'm afraid I was not even born. So I would guess that was probably a term of art because it is a quasi-judicial hearing. That's my initial guess at this point.
does anyone have issue if I take creative license and cross it out and put the word question?
I would like to do some further,
And let me expound on it for a second.
please.
When we start with only a party in interest shall be allowed to present evidence, testify, cross-examine witnesses, shall be allowed. That means we're excluding others, people in the city who are not in that neighborhood boundary. So for purposes of public hearing, anyone in the city can have their 3 minutes.
Yes.
Anyone who is a party of interest can be allowed to speak and come forward and do these other things if we allow it.
Shall be allowed. Not may be
A party in
allowed.
interest is required to be allowed if they don't meet the definition of a party in
And if
interest.
they
It would
choose
be
not to?
permissive, it would be, we would have some discretion.
So I would interpret this, I would say,
Yeah,
Only
should we
a party
drop
of
it?
interest shall be
Should we
allowed.
drop it?
only if they wished to, but only one of these people that meets this definition. But shall be allowed means that you would not be able to tell them.
Well, no, it says only a party in interest
Shall be
Right,
allowed.
but should
Right,
we
that's
drop
what I'm
That's
saying.
exclusionary, not inclusionary.
Yes, but that means that if they are a party in interest, if they meet that definition, then they do have that right. You cannot keep
But to
them.
Tim's point, if you had a member of the public who was
Right,
not
and
in the
that-
neighborhood,
They could still come up and speak
And
for
speak,
3
but they
minutes,
would
but
not
they
have
wouldn't
to
have
ask a
those,
question.
correct.
So an adult resident of the neighborhood would be a party in interest.
Right.
But
But-
somebody who did not live in the neighborhood
Their cousin from Kansas who's visiting and
could,
shows up.
or somebody who lived in a different neighborhood in the city but had an opinion about this for some reason, would be more than welcome to come and make public comment during the hearing for their 3 minutes, but they would not have any of the other abilities that this section calls out.
Unless. we
I brought
felt
this
it was
gentleman from
relevant.
Highlands
I
Ranch
think
because
we-
he's
we
had
have-
that happen to him,
Right.
and he doesn't have that right then.
Right. He could speak for 3
I'm not
minutes.
sure I would agree that if you felt like that you wanted them to ask questions, they would be able to.
well, no, because down at the bottom, provided however that this section is not intended to and shall not be construed as a limitation of the power of the authority.
Okay,
to
yeah.
cross-examine
For
question
you.
witnesses.
A limit on the power of the authority.
Right, but we could always, again, if a member of the public from Kansas got up and asked a series of questions.
You could then ask those
Yeah,
questions.
the applicant wouldn't
My
have to
cousin
answer.
is the preeminent liquor licensing lawyer in the state of Kansas and has a lot of experience in this. Maybe that would sway us to say, what's your question?
Well, yeah, and then
At
we
which
could-
point
we
you
could
would ask, as the
Yeah,
authority
we
would
could-
ask
yeah,
that
we
question.
would be the gatekeepers in that
Yes.
context.
Correct.
Yeah. Still disagreeing.
So you
Well,
think
so
taking out
what's-
the word only, is that what
No,
you're?
no, no, I'm saying the word only gives us coverage because it's not a party in interest shall be allowed, it's only a party in interest shall be allowed. So that's telling us, don't let anyone else cross-examine, testify, or present evidence.
Yes. However,
They can speak to their concerns.
however, another member of the public could certainly come up at public comment and have their 3 minutes. They just couldn't ask any questions or present any evidence.
So, to Tim's point, should we just add a sentence following that says, any individual present may speak during public comment?
I don't
Even though
believe
that's
that,
obviously
I
clear.
do not, it would not be my understanding that this section prevents public comment. If
Agreed, and I
that's
guess
the
my
concern.
point is, even
I
though we
don't
don't
know
think
that
it
you need,
does.
that you would need to call that
No, because
out.
public comment is part of our,
It's
part
part
of
of the
our
public
procedure
hearing.
anyway.
I'd rather not add.
Well, because
Right.
it's called parties in interest right now.
Correct.
I don't think.
And
that-
parties in interest is actually defined at state level via state liquor code. So that isn't something that we defined. We didn't make the determination that a party in interest is only an adult inhabitant of the neighborhood or only an owner or manager or.
In rereading this today, I thought about it, and then we had this example tonight. The party in interest is the applicant. It's an adult resident of the neighborhood under construction, under consideration. It's a representative of an organized neighborhood group, which encompasses part of all of the neighborhood. So it's an HOA, as long as such representative resides within the neighborhood group's geographic boundaries. This section goes a long way to preclude anyone from having their attorney speak for them, even to the extent that perhaps the applicant shouldn't have their attorney speak for them or present evidence or cross-examine. The way it's written. Now, I don't want every individual within the neighborhood to be able to bring an attorney and tie up and muck up the process, but I think perhaps we should add for the applicant or their.
We could add in the applicant or the applicant's agent or some language of that. Because we have had before where the applicant, the person who came in to give the presentation was an agent of the applicant, was perhaps their manager or.
Well,
Would
managers
agent cover
cover.
an attorney as well?
What?
Would an agent cover an attorney?
I believe it would.
In a broad sense.
Or their
There could be-
applicant or designee or some language to that effect, certainly we could add that in for, I would say only for the applicant.
Yeah.
Right. Okay. And we'll do some research on terminology to make sure that we're putting, whether it's going to be designee, agent, attorney. You know, because it may not be an attorney. It might be a family member. You know, maybe we have an applicant who English is not their first language and they're not very fluent in it. So they may have a family member who is English speaking come and make the presentation for them and kind of work as an interpreter, if you will. And we have seen that before. So I would be a little hesitant to just say attorney, because I think that's limiting.
I would probably lean toward applicant or designee or agent.
Designee or agent.
Representative.
Some language to the
Okay, you like
agent to
agent?
me or designee shows more of a
Contract sales.
Agent.
yeah, that shows to me more of like a designation of power or of you know, that you're giving them your, you know,
So you're adding this
filling
to
them
make a
with
G?
that.
No, we will actually, on A, it'll say the applicant or applicant's designee or agent or whatever verbiage we determine is best. So A would be applicant or applicant's agent. It would define what applicant is. I don't know that we need to add a G.
No, I think it makes sense to put
Agreed.
it there, because it's related to the applicant.
Yeah. Okay. Okay. I think we've made it through everything. Were there any other questions, concerns, areas that we didn't touch on? It's a whole lot of head shaking.
No, but it'd probably be nice, obviously we'll have a follow-up based on everything.
And we will work on that between now and our next meeting.
I was gonna say, it might be nice also to just
Have
make sure
a,
that, you know,
a summary.
Yes,
Absolutely.
but that the rest, and any of us too, have an opportunity in case we miss something or there's, you know.
Absolutely. And then in the interim, if you find yourself looking at it again and go, oh, I should have brought that up, shoot me a quick email, because I'm certainly happy to take a look at it, add it to the changes, make a end note at the end so people know where it came from and what the impetus was. I will probably go through and I'll leave the end notes in here for now, just as we're doing continual cleanup. But at some point, they will come out just to make it a cleaner process. So, okay. Well, that's all I have on this. Lena?
Nope, nothing
No, we're
else.
good?
Anything else from the authority?
Thank you for all your input. This has spurred some good
Awesome.
conversation. And thank you both for all your research and everything that we're dumping on you.
It's our job.
It's our job, and actually, you know, the reason we took this on, other than it really needed to be done, as we have found in many hearings over the years together about, oh, that says that, and it probably shouldn't, is I really wanted it to be not just a collaboration, but a great learning experience, because I'm sure there are things in the code that you never knew were in the code. And, you know, as the authority, I want it to be more than just a title. I really want you to be the authorities and to be able to go, yeah, I read that and I know where it is and I'm going to go find it, kind of thing. I'm weird about that. When I first, I'll just share with you real quick. When I first got assigned to this position as a temp in March of 2012, when I knew this was what I was going to do, I spent the weekend and read the state liquor code and liquor rules for fun, because I'm weird. And I didn't retain much of it, but as things started coming up, it was like, I read it somewhere, I'm going to go back, I'm going to research it. And I tend to learn better that way, and I hope other people do to an extent, and so that's really what.
So we expect you all to have read the entire state liquor code.
Well,
by the
the
next
more we
meeting.
touch it, the more we'll retain
Well,
and
and that really is. There will not be a test. There will not be a test.
Test is every month.
Yeah, the
out
test is
there.
every month in there, so.
It'll make us more credible.
So, and I, yeah, we absolutely appreciate all of your input.
Sure.
And
All of we ready to call that?
Yeah, we'll adjourn this
That's,
study session.
he's done.
Okay,
Okay.
adjourned.